So just to use your words, an extraordinary ruling in favor of Nigeria, because even though Nigeria had delayed and dithered quite a bit, this evidence of fraud appears to have given the government grounds for extension in order to try to prove fraud.
Absolutely, Charles. It's good to see you again. You've been away for a while. Welcome back to Nigeria. And yes, I was very thrilled to read the decision of Sir Ross Cranston, sitting as a judge of the Queen's Bench, in a 43-page, extremely well-considered decision. This decision must be published by the Nigerian government as an example of the cankerworm of corruption that pervades Nigeria. Right from the very top, a highly respected minister of international standing was involved. And what shocked me was he only got $10,000. This fraud, in the words of the former Prime Minister of the United Kingdom, is a case of a fantastically corrupt system. Kudos to the Nigerian government for fighting this through. And I think when I reviewed the 43-page decision, Justice Cranston struggled because it's difficult to get a stay, the type we've got. It's very, very difficult. So Justice Cranston made two important findings. First, that Nigeria had really no case for extension. But on the basis of strong evidence of fraud and corruption, it was minded on the balance the stay. And therefore, in considering the application that Nigeria made under Section 67 and 68 of the English Arbitration Act, I suspect that we will be victorious on appeal. So kudos to the Nigerian team, well done, and it established for Nigeria to be extremely careful. It deals with foreign contracts and even how it deals with the Nigerians employed to do these things, because across the chain, from those who represented Nigeria at the arbitration right through the NNPC, it was riddled with corruption.
Well, I mean, those are very good points you raise. But, I mean, I have to say, I mean, Olisa, you're a very well-respected lawyer, human rights activist and human rights lawyer. I mean, it's all rather a bit of a muddle, isn't it? Something of a shock as to how Nigeria got into a situation like this, where it's now potentially in hock to the tune of nearly $10 billion to one company.
Well, that's exactly the point. The need for government to act speed, the need for government to review its process, the need for government to be very alert. I've called for, in my capacity as vice president of the Nigerian Arbitration Council, for domestic legislation to prevent the sort of, contractual dispute to go to London. In fact, in the arbitration contract, the Nigerian law applied. Why somebody would have made England the seat beats me. So there were three issues that were taken in the arbitration. The first was the point of jurisdiction. Should Nigeria be the seat or the United Kingdom? We lost that. Second was whether we were liable to the company for not providing our own part of the bargain. And I was very happy that Mr. Justice Cranston showed very clearly that this Irish company were fraudsters. They did nothing. They did nothing beyond have a presentation. They had no money. They had gone to General Danjuma for money. They conned him. They bribed the entire chain, NNPC at the time. So I think the lesson from this is we must be careful how we procure our contracts. It's a real big lesson. And the shame of it is that there is a stack of arbitration awards pending against Nigeria. And therefore, this 10 billion award, which I'm sure will win on appeal, is but one. There's one for 2 billion that I'm working on. There's another one for $3 billion. So if we had allowed all this to occur, 3 billion here, 2 billion there, 10 billion, you can imagine what will happen to Nigeria's resources. So it's time for us to rethink how we organize government business. It's time for us to, domestically, we must not allow contracts that are essentially Nigerian to be resolved in foreign jurisdictions.
Well, that's a very important point, and particularly the point you raised about what this is doing to Nigeria's resources, or potentially could do, because I did a bit of research there, and the amount in question, $9.6 billion precisely, which I understand is the equivalent of around 3.5 trillion naira. I understand it's apparently more than the entire tax collection that Nigeria made last year in 2019 in all the country's 36 states. So that's an enormous amount of money, which is why, of course, today's ruling is hugely significant.
No, absolutely. There's no question that every Nigerian who has heard about this will be extremely relieved. When I read it, and so that Justice Cranston had given us a stay, and that not only did he give a stay, it's important to clarify this, because in giving a stay, he considered whether Nigeria had made out a prima facie case of fraud, which is the only point we have on appeal. Because quite honestly, in arbitration, there's finality. Once the arbitral award was handed down and we had lost time, we couldn't come back and ask the court to reopen. So the challenge Nigeria had was presenting evidence before the English courts that there was fraud. So following the finding that there was fraud and the court accepting to extend, and my view is that the final decision will be in our favor. Well, it raises all sorts of concerns in my mind about how government is run. In some cases, the reason for delay was that the Ministry of Justice at the time, not under the present Attorney General, just couldn't give the document to the retained counsel. Can you beat that? Such crass negligence, and the judge pointed it out in his 43-page decision. Delay upon delay due to the fact that government does not see this as commercial business and a potential loss. So I hope this will be a big lesson. And I would urge the Attorney General to extend a sweeping rule in respect of other arbitral awards that Nigeria has lost, so that we don't just go down the drain. This is $10 billion, tomorrow it could be $5 billion.
Well, absolutely. But I mean, Dr. Agbakoba, beyond the allegations of fraud, which seem to have given Nigeria a lifeline in this case, P&ID have argued that the Nigerian government failed to provide the infrastructure that it was contractually required to do as part of the deal. I mean, I wonder whether that is going to form a big part of the case going forward, the fact that Nigeria failed in its contractual obligation to provide that infrastructure, or is the case now going to hinge on the issue of fraud?
Only fraud. Nigeria has lost the case on the merits. We lost jurisdiction. We lost the issue of liability. In other words, was Nigeria liable for not performing that? And then we lost the issue of quantum, the three important elements in the arbitration. And it was on quantum that a Nigerian arbitrator dissented and awarded 50. So even the Nigerian arbitrator accepted that there was a good case. At the time the arbitral award was handed down, no, the monumental fraud. It was only when these fraud issues came to light that Nigeria went back to the English courts to say, as a matter of English public policy, it is not possible for an English court to condone fraud. And that was the point brought before Mr. Justice Ross Cranston. And in the review of his decision, he agreed entirely. The entire thing smacked of fraud. And he couldn't even see the evidence because P&I claimed that they had expended resources. He said, well, what did they do? All I can see that they did was a presentation, a digital presentation at the NNPC. They hadn't even paid for the land in Calabar. They had been allocated the land, but they didn't pay. They hadn't spent a dime. So how could they be entitled to $10 billion? And I think that decision was a very sound decision by the judge.
Well, I mean, coming from people like you, we obviously place tremendous weight on your assessment. But now the judge did not specify the length of the extension in that long-running dispute, did he? So it could conceivably drag on even beyond the life of the Buhari administration, which is due to end in 2023.
No, I hope not. I think what Nigeria should do now is take advantage of the relief from sanctions and put in the proper papers in good time. That will show good faith. And that will demonstrate to the English courts that Nigeria is serious about presenting its case on fraud. I don't think that this is a matter that should lag at all. I would hope that the Attorney General of Nigeria, Mr. Abubakar Malami, will be on top of matters and press this with the utmost speed and it deserves. And I'm sure he will do that. I'm very sure and certain.